Hello, everyone. This is Madison Benedict, an attorney in Husch Blackwell's Renewable Energy Group. We are excited to welcome you to the second installment in Keeping Your Project on Track webinar series. Today, we will be discussing mineral issues in Texas wind and solar project development. Before we begin, I'd like to cover a few housekeeping items. At the bottom of your audience console are multiple application icons for your use during the program today. I'd like to take a minute to highlight a few of the key icons for you. If you have any questions during the webcast, please submit your questions via the question box. We will try to answer all questions during the webcast today, but if a fuller answer is needed or we run out of time, it will be answered later via email. We truly appreciate audience participation and encourage you to submit questions, which we will answer at the end. There is also an icon to assist with your viewing preferences. Accordingly, please note that you can expand your slide area by clicking on the maximize icon on the top right of the slide area or by dragging the bottom right corner of the slide area. If you have any technical difficulty, please click on the help icon. It has a question mark and provides information regarding common technical issues. A copy of today's slide deck is available in the resource list icon that looks like a folder at the bottom of your screen. This program has been approved for Colorado, Illinois, Iowa, Kansas, Missouri, Nebraska, Tennessee, Texas for continuing legal education credit. Wisconsin continuing legal education is pending. To report your hours in Illinois, Kansas, Nebraska, Tennessee, or Texas, click on the CLE widget at the bottom of your screen and complete the questions. You'll need your bar number to submit. A recording of the webcast will be available tomorrow for watching and sharing. Once available, a link to the recording will be emailed to you along with a certificate of attendance. So joining me today is Brian Poland, who is also an attorney with the Renewable Energy Group. Brian and I have focused our entire legal careers in energy and real estate law. Our practice in the renewable energy context focuses on development and financing of wind and solar projects, and Brian has an extensive background in oil and gas, which uniquely situates him to discuss the issues we will cover today. So, to get started, I'd like to give you all a preview of some of the topics we'll be covering and set out an agenda. First, we're going to be covering some of the basic legal principles of mineral ownership and the due diligence that's necessary to determine the mineral ownership. We'll also touch on a few common issues that arise in wind and solar development and how to mitigate the risks associated with such issues. And lastly, we're going to cover a few points relating to title insurance, which is another mechanism for mitigating risk in renewable projects. I'll note that our primary focus today will be on Texas and Texas law and Texas common practices. However, if you have a question that's unique to projects outside Texas, please don't hesitate to leave a question via the question box and we will try to answer. So let's start with the basic legal principles of mineral ownership in Texas. Texas law recognizes two different estates in real property, the mineral estate and the surface estate. And both of these estates carry with it distinct types of property rights in the land itself. The mineral estate gets created when someone severs a mineral interest from the surface estate. And it's best to think about these two estates as completely separate with completely separate ownership. Just like the surface estate, it's not uncommon to have more than a handful of mineral interest owners. And in the chain of title, there can be multiple reservations of mineral rights or royalty interests or other rights in the mineral estate. And just like there can be different rights in the surface estate that are split up, there are different levels of rights of mineral ownership. You have executive rights, development rights, royalty or payment rights, and all carry with it different aspects of ownership and different rights. A mineral owner who holds the executive rights, for instance, has the right to lease the property to a mineral lessee, which becomes important in the solar context. If someone solely has a royalty interest, they do not have the right to lease the property. They only have the right to receive payment. Moving on, under Texas law, the mineral estate is dominant over the surface estate. And what this means is that the mineral interest owner has the right to use as much of the surface, subsurface, and adjacent airspace as is reasonably necessary to enjoy the surface estate. So, at first blush, this seems like an extremely broad right, and there are extremely broad rights that are granted to the mineral interest owner. However, there are some limitations that we'll discuss further on in the webinar, including the fact that a mineral owner must give due regard to surface owners' uses. The idea behind mineral estate dominance is that if a mineral owner cannot access or use the surface of the property, they won't be able to develop the mineral estate. And the law likes to encourage development and not render land and interest in the land just completely worthless. If they don't have the access rights to the land, they can't develop the mineral estate. So in the event of a conflict between a mineral lessee's use of the surface and a surface owner's use of the surface, the mineral lessee's use will supersede the surface owner's use. This sounds extremely prohibitive, but it does not wholly prohibit development of the surface estate. Mineral interest owners' rights are subject to a few limits, which I'll discuss right now. So, although mineral interest owners have very broad rights, a mineral lessee, there are limits on these rights. A mineral lessee is going to have the right to use the surface to search for and produce minerals if their use of the surface is reasonable, in accordance with the accommodation doctrine, for the benefit of only those minerals underneath the land, and in accordance with the terms of the lease that they're operating under and any applicable statutes, ordinances, rules, or regulations. The first bullet point, the reasonable use element, means that the mineral lessee's use must be reasonably necessary to develop and produce those minerals conveyed to the mineral lessee. Activities such as conducting seismographic tests, building structures on the land for production and storage of minerals, building roads, drilling water wells, using water from the land to pressure wells, all of these have been held to be, quote, reasonable uses by Texas courts. The second bullet point, the second limit, is the accommodation doctrine. As many of you know, this is a common law doctrine that can, in certain circumstances, create an exception to the rule that the mineral estate is dominant. What it requires is that a mineral lessee requires a mineral lessee to accommodate a surface user's use if certain elements are satisfied. And we'll discuss the accommodation doctrine in a lot more detail later. Third limit on mineral ownership, a mineral lessee's use of the surface must be for the purpose of obtaining and producing only those minerals under the corresponding surface estate. The Texas Supreme Court holds that a mineral lessee cannot use the surface of the land to obtain minerals located under other tracts of land without the surface owner's consent, even if the mineral lessee owns leases to those other tracts. However, we'll note that pooling oil and gas leases has been noted as an exception. Then lastly, last bullet point, limit on mineral ownership. Mineral leases will typically specify drilling sites or otherwise place limitations on the mineral lessee's use of the surface, so they will obviously have to comply with such requirements. Mineral lessees in Texas also must comply with regulations established by the Railroad Commission of Texas, which Brian will discuss a little bit later. I'm now going to turn things over to Brian to talk a little bit about mineral due diligence in wind and solar projects.
Thank you, Madison. I think first we're going to do the poll question. And the poll question is, what do you typically rely on to confirm mineral ownership? A mineral ownership report, a mineral title opinion, a title company search, or nothing? I'll give you a few seconds to answer that. So it looks like we have most people rely on a mineral ownership report, and that's good that there's 0% on nothing and 0% on title company search. So the mineral ownership report is what is commonly known or commonly used. The first thing to know is a developer cannot rely on a title commitment. The title company is not required to search out all the mineral interests because they're not insuring the mineral estate. The title policy only insures the surface. However, the title company will want to know the mineral ownership in order to issue the T19-1 and the Texas T19-1 and T19 endorsements, and also express coverage, which we will get into more later on. The first step the developer always wants to take is to hire a mineral land company to conduct a title search of the minerals. The mineral company will search county records for mineral severances and any active oil and gas leases. Once they have that information, they put together a mineral ownership report. This report sets forth what the mineral company sees the mineral ownership as, and then also will include a list of all the documents that the landman who searched the records found. Typically, this will be reviewed by the attorneys just to confirm there's no issues that they see, and so they can work with the landman to cure any issues. There are three main reasons mineral ownership needs to be determined. The first is that the title company will require surface use agreements or set-aside agreements, also known as accommodation agreements, to be executed by the mineral owners to issue the endorsements that the developer needs on the title policy. And they will want to ensure that these agreements are executed by the right parties. The second reason is the developer needs to know if there's any oil and gas activity around the area that is active. For example, the mineral ownership report will show if there's any active leases, or if they see that there's any active leases, or if any leases within a primary term of that lease. The attorney representing the developer and the mineral title company will work together to review this ownership and look for any issues. Knowing the activity in the area helps the developer work with the title company on the percentage of mineral owners that need to execute the surface use or set-aside agreement. It also helps the developer in siting of the project. Finally, a developer needs to know this information because most often they will be required to make payments to mineral owners for these set-aside agreements. Without knowing the mineral ownership, the developer cannot be confident in who they're making these payments to. Now, mineral issues tend to be come up more often in solar projects because the panels could cover most of the section. However, in a wind project, while the facilities take up less of the section, and typically a mineral owner and developer will not have any issues working together, but this is not always the case. It is important to understand the mineral ownership and oil and gas activity in the area for wind projects, especially in tight corners or in locations of the transmission line. Recently, we have seen issues where there was an old oil and gas lease on the project that was held by production, and the current owner of that project wanted to drill a new well and had the right to drill a new well under that lease, very close to where the developer wanted to run the transmission line. This created an issue as the oil and gas company was attempting to block that transmission line from being located there. Because we did work with the developer and we knew the mineral ownership, even on a wind project, they were able to negotiate with the oil and gas company and come to an agreement on joint development. So most of you answered that you do use a mineral ownership report, but there was about 20%, I believe, that said they do get mineral title opinions. The difference between a mineral title opinion and a mineral ownership report is that an attorney will actually review all the documents, or the mineral documents the title company pulls, and review those. The attorney then will write an opinion as to mineral ownership. These are typically written for oil and gas companies. And when the oil and gas company requires a title opinion, you get into a lot of different ownership. It will cover surface, mineral, leasehold, any joint development between two oil and gas companies, royalty interest, overriding royalty interest, non-participating interest, the list goes on. For a renewable energy developer, this is not needed. What would be needed would be just a mineral ownership and leasehold ownership for the working interest owners. the renewable energy developer would not need to know, for example, any non-participating owners or overriding royalty owners, because those owners will not impact their project. A mineral ownership report will typically have some type of disclaimer that is not a title opinion. So one reason that you might want to get a title opinion is that the records are actually being reviewed by an attorney and a opinion is being given. The developer can be confident that they are paying the correct owners because they would actually have an opinion. And as mentioned before, title policies do not cover mineral ownership, so this is a way for a developer to be confident they are actually obtaining these mineral agreements from the correct parties. There really is not any disadvantages to obtaining a mineral title opinion. As of now, I have not seen a title company require a title opinion to issue the express coverage or endorsements. Title companies will typically rely on mineral ownership reports, or they may be obtaining their own opinions internally. These opinions would just be an extra step in the developer's attorney's review, and as payments continue to increase or may continue to increase to mineral owners, the developer can be more confident that they are paying the correct parties. And I think next is the next poll question. And the question is, have you used the Texas Railroad Commission to review oil and gas activity at your project location to help determine site selection? I'll give you a few seconds to answer that. I got a 50-50 split. So one step that we do internally when we're doing solar projects is we will review the Texas Railroad Commission. And the reason for this is it helps limit the risk of mineral estate interference and potential future accommodation doctrine issues. What we do is that we will look at the past oil and gas production and regulations from the Texas Railroad Commission or cities. The Railroad Commission has the authority to pass spacing and density regulations applicable to oil, natural gas, coal, and other minerals. Many cities can pass further ordinances and regulations as long as they do not conflict with those of the Railroad Commission. For example, there are state and countywide spacing rules that oil and gas developers must comply with. By doing a search of the Railroad Commission and checking the spacing and density requirements, we're able to we can determine whether developers' proposed design leaves enough space for oil and gas development. This helps when you're negotiating with set-aside areas with mineral owners and developers, as you will be able to say, well, we know that you can drill here because you have enough space, or we've left you enough space to conduct your operations, and that just helps with the negotiation. The Texas Railroad Commission also includes a map which shows active wells, plugged wells, dry holes, permitted wells. They'll show pipelines, and many other things are on that map. This review is important for planning and siting of the project. So an oil and gas developer filed a permit with the Texas Railroad Commission prior to starting their oil and gas operations. So every section in the solar project, and really probably the wind project too, needs to be reviewed to determine whether there's any oil and gas activity being conducted on the project or if any permits have been filed. If there's already activity or permits on the Railroad Commission, this will help the developer in siting of their project, and will also alert the developer to set aside areas that they need to ensure that they're leaving. As I mentioned also, it's just another negotiation tool that you can have when you're working with the mineral owners and oil and gas developers, as you already will know where the oil and gas developer plans to drill. If there is any activity or active leases, the renewable energy developer for a solar project will need to obtain surface use or set-aside agreements with the actual oil and gas lessee, in addition to the mineral owners, and this is because that mineral lessee has the current rights to be out there. But we recommend also looking at getting them from the mineral owners as well, because if there is not any production on that lease, that oil and gas lease will expire, and you want to make sure that you have agreements in place with the mineral owners who will now own those mineral rights. One thing to note is that the oil and gas developers do move very quickly. So while the Railroad Commission is a good tool, it may not show all the permits. Now, they say they update it every night, but that may not be the case. So it's a good tool to use, but it cannot solely be relied on. As I previously mentioned, while solar projects typically create more issues, we should check the oil and gas activity for wind projects, especially on those transmission line and collection line areas. But the main focus should be for solar projects. And I'm now going to turn it over back to Madison to discuss some common issues.
Thanks, Brian. So we've discussed a little bit about determining who owns the minerals and what rights do they have, but now we face the question of what do you do about them? Some of the common issues that come up for solar and wind include, what kind of protection should I write into my lease? Where should I site my facilities? Based on the review of the Railroad Commission that Brian just discussed. Is there anything under Texas law that inherently protects the project? What non-contractual options do I have? What contractual options are available so that I can help make sure that a mineral lessee doesn't force the project to be removed? Other common issues are what protections can title insurance afford? And we'll address all of these questions in the coming slides. But first, let's take a look at some of the non-contractual ways that you can mitigate risks to your project. So as these pictures suggest, and as you probably know and has been alluded to throughout this presentation, between wind and solar, wind projects are much more favorably situated to share the surface with mineral interest producers than solar projects are, and that's simply just due to the amount of land that is left open and untouched in wind projects compared to solar projects. Solar facilities are blanketing large blocks of land, might leave little open space for drilling opportunities, whereas wind, on the other hand, by design, they're much more accommodating to mineral interest owners. Therefore, it's significantly easier for wind energy facilities to coexist with oil and gas facilities, and this is very, very common in Texas. However, I do not want to imply that solar and oil and gas cannot coexist. It just takes some more upfront planning to make sure that the mineral owners are being accommodated. Searching out the mineral owners, looking at the Railroad Commission, determining what needs to be set aside for them in order to make sure that the project can continue to operate and there's no forced removal situations. Now we're going to turn to the Texas Accommodation Doctrine, which at its core requires a mineral lessee to give due regard to a surface owner's use. The Accommodation Doctrine is a multi-factor test. It's extremely fact-specific, but it does offer users of the surface estate some protection from the idea mentioned earlier that a mineral lessee has the right to use so much of the corresponding surface as is necessary, reasonably necessary to enjoy and develop the mineral estate. We won't be discussing in depth the factual analysis and legal nuances around each specific element of the Accommodation Doctrine, because as I mentioned, it's very fact-specific and depends on the circumstances. of each case, but instead we'll try and give a general overview and a few details of how a surface owner would establish a successful claim under the accommodation doctrine. So the first element a surface owner must show to have a successful claim is that at the time of the mineral lessee's proposed use, meaning their operations are drilling, installing wells, etc., the surface owner has an existing use on the land. Generally, the accommodation doctrine does not operate to protect future uses of land where drilling operations have already commenced. Texas law is not extremely clear on how this, quote, existing use element would apply to wind and solar projects and what level of use would qualify as an existing use, how far down the chain of operations or chain of construction what level of construction you have to reach before it's considered an existing use, or what level of operation you have to reach before an existing use. But Brian will discuss this a little bit more later. The second element that a surface owner has to prove is that the mineral lessee's proposed use must substantially interfere with the surface owner's existing use. This is going to require proving that the existing use of the surface is completely precluded or substantially impaired by the mineral lessee's use of the surface. That is, their drilling, their operations, their, exercising their lease rights to the mineral estate. And this element in particular, in addition to all the other ones, is very fact-specific. It would likely be more difficult for a wind developer to prove this element. But for solar, the reason being that wind, by design, much more spread out. There's more, flexibility in terms of locations. Whereas for solar, proving this element would likely be a lot easier, that there would be substantial interference. The third element to have a successful accommodation doctrine claim, the surface owner must have no reasonable alternatives to continue its existing use. So in renewable terms, the developer must have no reasonable alternatives to continue the project as it is currently planned or operating. To prove this, you'd have to show that either one, there's no alternative location or configuration available on the leased premises. The panels must go here and they may not go anywhere else, or the turbine has to be here and it cannot go anywhere else. Or second option is that the financial burden of continuing the existing use by any proposed alternative means is so great that that alternative means is completely unreasonable. And when I say financial burden being great, it's not that it's an increased cost. It has to be it's a significant financial burden. So in the solar context, this means that the expense and cost of moving the panels, moving the facility to a different location would be so great as to make it unreasonable. A court would find it unreasonable to force the facility to relocate or to move panels. I'll note that it's insufficient for the surface owner to prove that a reasonable alternative method is merely inconvenient. Inconvenience is not something that a court would be sympathetic to. It really ties back to whether the current configuration and the current location of the project is the only means to operate, or the financial burden of moving is just so significantly great that they won't force you to move. Lastly, as to the fourth element, the mineral lessee must have a surface owner must prove that a mineral lessee must have reasonable industry accepted alternatives available that would allow them to recover the minerals without interfering with the surface owner's existing use. Essentially, the purpose of this element in the wind and solar context would be to prove that the mineral owner can still develop the minerals on the project site while also allowing the project to remain and operate as well. Directional drilling is considered an industry-accepted alternative under Texas law, but this is as long as the directional drilling can occur on the premises in question. I'm going to turn it over to Brian to cover a few more points on the accommodation doctrine.
Thank you, Madison. As you mentioned, existing use is an element of the accommodation doctrine, and it is not a fully resolved issue in Texas. There are cases out there, but it's not as clear as we would like it to be. Our opinion is that the project has to be at least started in order to be built, or for the existing use to be applied. And the closer you are to actual completion, the better. There are cases that are not in the renewable energy context, but that if you have phases of a project and your first phase is built, but your second phase is not, and the oil and gas development is to occur on the second phase, there is a case that is actually on a landfill case that says that the accommodation doctrine would apply to that second phase even though it has not started, because the landfill company had no other use but to put their trash in that second phase of the area. So while the development there was no landfill development on this second tract of land, the accommodation doctrine still applied because the other elements of the accommodation doctrine were met. There was no other use available to the landfill company. So the point of the accommodation doctrine, I think, that is most relevant is that is very fact specific, and it is not something that we hope to rely on. We hope that you can work with the mineral developers and we can get the set-aside agreements. But there is a alternative, and that's why it's very important that the developer works with his development attorneys, and if we do need to do this, and we do a fact-specific analysis for the project. Again, not something that you want to rely on, but it is something that you may be able to rely on. And when we talk about existing use, it is not something that we can say exactly existing use occurs at this point. It is something that we work with, and we will work with the title company, we will work with the developer, and we can say, maybe we can give you start this section first if you don't have as many set-aside agreements. You can work with your construction schedule if it is something you have to rely on. But again, that should be a last resort, hopefully, because financing parties, title companies, and the developer themselves do not want to rely on the accommodation doctrine, and we will want to, as much as we can, get set-aside and surface use agreements with the mineral owners. So, as I mentioned, accommodation doctrine is not something you want to use, but it is something you should plan for, which means that site selection is key on any project in every respect, but when we're talking about minerals, it's very important for the coexisting of mineral owners, mineral developers, and the renewable energy company. And the reason is, as we've mentioned throughout the project, oil and gas is dominant in Texas, so we got to pay attention to our site so we ensure that we're not interfering. If the developer does not set aside areas for mineral development, the first issue is right off the bat is that you're not going to probably get the mineral owner or the mineral lessee especially if there's a mineral lessee, to cooperate. If we're talking as a mineral lessee, they have an oil and gas lease because the plan is to develop that area. If we're both, there's no reason, as Madison mentioned, that you cannot coexist, especially with horizontal drilling. But if we can show the oil and gas lessee that we've thought about their development and we can set areas, it just gives you a leg up in the negotiation, and you'll know what their plans are. Secondly, if for whatever reason the developer cannot obtain or does not obtain set-aside or surface waiver agreements from all the mineral owners or a significant portion of the mineral owners, the next step is going to have to be to work with the title company and the financing parties to get them on board with moving forward with the project. Thus, when you do site selection, you want to be able to show that your site selection leaves enough room for mineral development, and the accommodation doctrine would apply in the future. For example, we had a project that there was a lot of severances. There's just not physically possible to get set-aside agreements. But we were able to do an analysis of the project, and the developer did an excellent job of thinking about site selection, and we were able to get financing parties on board and work with the title company to get them on board to show that the accommodation doctrine would likely apply, and work with the title company for options to make sure we got the necessary site selection, and just work with the title company for what will happen in the future once a project is built. As we've mentioned on numerous occasions, the accommodation doctrine has to be able to show that the mineral developer has other alternatives. And if the solar developer is careful in its site selection and has their development attorney review, we talked about the Texas Railroad Commission for cash production, county and city regulations, Railroad Commission regulations, and we can show the financing parties and the title company that we've left enough room, it just gives the developer an easier argument that he's thought about it, and even though he's not able, or they are not able to secure set-aside agreements, mineral development, there won't be any mineral development interference in the future, just because we haven't been able to get all the set-aside agreements. It's just another, the Railroad Commission is just another tool, site selection is just another tool in the developer's arsenal to work with the mineral owners and the title companies. And one of the options the solar developer has is to consult with engineers, and there's companies out there that will help you with site design that you, especially if the minerals are heavily severed and it's clear that you're not going to be able to get them. We could work with an engineer and work with your development attorney to set your site selection. But just to, I think, note that the first step is to try to get as many set-aside agreements as you can. The accommodation doctrine is not an easy thing to analyze, and we want to ensure that we get as many set-aside agreements as possible. And it's also just talking about site selection. The Railroad Commission shows you where the plugged wells are, the dry holes are, and it's just important to take note of those areas. While it may not be required, you should try to avoid those as much as possible, just for any environmental issues that could come up in the future. You don't want to get into a situation where the plug breaks and now a oil and gas developer has to get in there and do something. It's very unlikely, but it's just something to consider when you're doing your site development. And then pipelines is just another thing to be monitored. Not all pipelines can be avoided, and we do a full crossing analysis, and we'll determine what pipelines should be avoided. But in just doing your site selection, it's just important to take note of them and try to avoid them as much as possible. It just lessens the work that has to be done. So not attending as many crossing agreements is much easier. So just another thing to consider when you're doing your site selection. Now we're going to talk a little more about contractual ways to mitigate risk and do a poll question. And the question is, have you worked with mineral owners in the past to obtain set-aside or surface use agreements for wind or solar projects? Okay, we got 75% says yes, 25% no, says no. So let's talk about surface waivers first. As we've mentioned, mineral rights holders have broad rights. So the best option is to contractually limit those rights. And first option we always try to get is, which is the broadest, is a contractual limitation for a full surface waiver agreement. And here the owner of the mineral estate waives the right to use the surface of the land where the project is located. Sometimes mineral owners may not be inclined to sign such a broad limitation because it is a waiver of the right to use the surface. So to ease this concern, we can draft the surface use agreement to not only protect the solar developer, but also allow the mineral owner to still develop the land and through horizontal and directional drillings that don't impact the project. When these stipulations are included, mineral owners may be more willing to sign the agreement. And one of the ways we can do that is by doing a surface waiver of just the fenced project area. What that does is the actual waiver only applies to the fenced area, and it allows the mineral owner to place oil and gas locations off those areas and drill horizontally underneath the project area, which we limit that typically to 500 feet below the surface. When we do that, it's just very important that these waivers are carefully drafted, because we want to ensure that the project company still has the right to lay collections, transmission, place roads outside this project area. So it's very important that we draft these carefully, and we talk to the project company, the developer, and the project construction team, and we just work together to make sure we properly draft these agreements. The second option, and what I think is what I'm seeing more common, are set-aside agreements or accommodation agreements. And these agreements are another contractual limit to the mineral rights holder, but on a much smaller scale. And typically they will establish drilling locations within the project boundaries, or they will actually, there's two options. You could do it as drill pad locations or an actual full-out set-aside area. For example, on the north section, 300 feet by 5,280 feet, because that's just typically a section area. We've seen that. The other option is that we've also seen setting actual drill pad locations. It's just a way that will, not a full-out waiver, but a way to allow both the coexistence of the minerals and the solar development. When we draft these are very important that we draft these very carefully. The typical provisions that we want to make sure as we set specific drill pad sizes and location, shared use of roads, notice of operation provisions, assignment rights, and as we've talked about in surface waivers, we also need to make sure that these agreements are carefully drafted to allow for transmission lines, collection lines, roads to cross into the set-aside areas. For example, in many projects, we've seen that the collection lines, roads, transmission lines, any other facilities are not just set in your project area, obviously, or your fence project area. So we will, if it's the set-aside agreement or accommodation agreement is not carefully drafted, a developer may run into a situation where their project is built or is planned to be built, and they don't have the right to put a collection line through the set-aside area. The mineral owner will also likely want to place limitations on how many roads can be placed or how wide the roads can be placed, or how wide the roads can be. And they also will think about limiting how much, whether the collection lines and roads can be next to each other. We've seen issues with this in the past, so it's very important that developers, construction teams, and attorneys work together to set these areas and make sure that the locations are determined prior to this set-aside agreement being executed, and make sure that the actual future development, when the project is actually built, we are not running into a situation where the surface use agreement is violated. I'll turn it back over to Madison to discuss some lease provisions that need to be put into leases as well.
Thanks, Brian. So, surface use agreements and surface waivers, a lot of that is third-party focused, outward focused, but there are a lot of protections you can gain just through protections you can gain and contractual limits on mineral rights that you can get in your site control documents with your landowner, with your main landowners. For solar projects, it's important to work into the lease and express surface waiver from the landowner using all of the principles and keeping in mind all the things that Brian discussed a few slides ago. The surface waiver should expressly include the successors and assigns, so that if the landowner sells off the property, you're still protected. Additionally, you should also keep in mind that when recording a memorandum of your lease or easement or whatever the site control document may be, this surface waiver should also be listed in the concepts that are included in the memorandum, in addition to the term of the lease, all of developers' rights, all of the things you would typically include in a memorandum. The surface waiver should also be included in that. The landowner will likely request in the lease to make it clear that they're reserving all of its interest in the mineral estate, and that's obviously fine, but this should be subject to the surface waiver. Additionally, in a solar lease, most leases contain a non-interference provision, typically in the warranties or negative covenant section of the lease. And this is going to detail all the ways in which the landowner's activities are limited so that they don't interfere with project operations. So I would recommend ensuring that this section also includes a restriction on granting rights to third parties after the date of the lease that would interfere with project operations. And the idea there is obviously to capture any future grants of oil and gas rights that the landowner may make. This is also a good idea for any adjacent property owned by the landowner or area outside the solar panels that's within a buffer area. For wind, on the other hand, not necessary to obtain a surface waiver, and also probably would be completely unacceptable to the landowner. So instead, your primary protection in your site control document is going to be a strong no interference paragraph that's restricting the owner's activities, including what was discussed above with restricting the grants of rights that the owner makes to others, making sure that any rights that not restricting their rights completely and that they cannot grant any, but making it clear that when they do grant rights, that such rights will be subject to the wind lease, and that their operations cannot interfere with construction, access, development activities, or any other activities or rights that are allowed under the lease. So continuing on with contractual risk mitigation techniques, wanted to touch on title insurance a little bit. Obtaining protections in a title insurance policy is another great way to mitigate risks that are posed by mineral interest holders. For wind specifically, this is your primary mitigation tactic, which, because as discussed, surface waivers are not typically necessary for the majority of the project, and surface use agreements are not common. In Texas, you have 3 primary mineral endorsements that you can get on an owner's and loan policy. The T19-1, which goes to the owner's policy, not listed on the slide, is the T19, which goes to the lender's policy. Same thing, just different numbers for different policies. T19-1, T19 are comprehensive endorsements that cover multiple issues, not just minerals, including violations of covenants on the land, encroachments on easements, but most importantly for our purposes, damages to project improvements that are due to mineral production. The T19-1 carries a lot of benefits because it is so comprehensive. However, it is pretty costly. For an owner's policy, the cost will be 15% of the policy premium amount. So, on these wind and solar projects where you've got a policy amount of upwards of $100 million, the 15% of the premium amount gets pretty high, can be into the triple digits. To issue the T19-1, the title company is going to require an ALTA survey to review, and also, according to Texas Department of Insurance rules, they have to include the Texas promulgated general mineral exception. And I mention it now, but we'll touch on that a little bit more in a few. I see we're running out of time quickly, so we'll try and speed it up a little bit. The T19-2 and the T19-3 are the other 2 endorsements that are available. These are much less costly, $50 each. And title financing parties typically do require them. More often require the T19-2 because it's more applicable to wind and solar projects. A T19-2 is going to cover damages to improvements that are located on the land on or after the date of the policy due to mineral exploration and development, whereas the T19-3 is going to cover permanent buildings on the land. Improvements is typically defined elsewhere in the policy. There's language that you can include that defines improvements as electricity facilities in your panels or turbines and all the other adjacent improvements, so that all the improvements will be covered. So in addition to the T19 series endorsements, in Texas you can also obtain additional protection from mineral interest through what's commonly referred to as express coverage or sometimes affirmative coverage. The difference between express coverage and the endorsements is basically what is covered, what the title company is going to cover. While endorsements cover damages to improvements due to a mineral owner exercising their rights, the express insurance is going to cover access to those improvements. In this slide, I've included an excerpt of the typical express coverage language as it pertains to minerals. This is an example, but please note title companies may have different language, different tweaks in what they typically are willing to give. And as you can see from this, the title company is essentially agreeing to provide coverage for losses sustained if mineral rights owners prohibit your right to access a wind or solar facility. Important to note here that the title company, with this express coverage, the title company is not covering lost profits or the cost of obtaining additional land rights if a mineral owner is acting to prohibit access. Instead, a project developer would typically rely on business interruption insurance or something similar to cover lost profits in that scenario. As mentioned earlier, in order to get the T19-1, the Texas Department of Insurance requires what's known as the general mineral exception, and it's a promulgated exception that appears in Schedule B along with all of the other Schedule B exceptions to title insurance. And what it does essentially is carve out any mineral severance or lease of record from the insurance you're getting from the title company. Brian alluded to this earlier. Title companies are, the reason this exception is included is because title companies are not required to do a full mineral search for their policies, and because their title search does not necessarily capture all of the mineral interests and leases and royalty reservations that affect the property. The Texas Department of Insurance takes this into account and allows them to insert this exception as protection for themselves. So this will be required on the T19-1 to get the T19-1. Best practices on the general mineral exception for both solar and wind is to request that the general mineral exception is added to the list of exceptions that are covered by the express coverage to ensure that there are no carve-outs, unintended carve-outs to the mineral coverage. I'll turn it over to Brian to touch quickly on title companies' requirements.
Thanks, Madison. Yeah, this will vary by project. Title company is likely reviewing the same documents and information that the developer's attorney or the developer themselves should be reviewing. And it's just important that the developer's attorney, the title company, they all work together to look at the ownership reports or title opinions, look at the railroad commission, look at the past production, and determine an amount. If the parties are engaged in talking early and often, the developer can be sure that there's not going to be any surprises that occurs, and both sides will be able to assess what the requirements will be. Talk for a few seconds on what the best practices that we have seen in the project. First off, it's important when you're working with a title company to get it to underwriting as early as possible. We don't want any surprises, especially a day or two before closing. So it's best that when we're talking about minerals, that the pro forma submitted to underwriting, and so we make sure that there's no issues on the T19-1, T19-2, or any express coverages. Secondly, mineral searches and contacting mineral owners, I cannot stress this enough, as early as possible in your development stage. Mineral owners, especially in West Texas, are savvy, and they will take some time to negotiate. It's not uncommon that we talk about months when we're talking about negotiation. So just starting this project as early as possible, and then finally just having all parties engaged early on when we're talking about title companies, mineral search companies, development attorney, development, construction team, all parties talking early and often, and we make sure that we get the proper coverages that we need and proper amounts for the project. Finally, just wrapping up, here's a couple of useful resources that we have. One is a link to the Railroad Commission map. These slides are going to be available after the webinar, so just wanted to provide you a couple, an article and the online map.
I see that it's we've hit 1 o'clock, so run over time a little bit. There are a good number of questions, and we see that. We will have access to these questions after the presentation. So for those of you who submitted a question in the question box, we will reach out to you and answer your question. Well, thank you for joining us for our program today. We hope the information provided was helpful for you and your organization. If you haven't already, please click on the survey icon at the bottom of your screen to complete our short survey. Your feedback assists us in providing quality future programs. As a reminder, this program has been approved for Colorado, Illinois, Iowa, Kansas, Missouri, Nebraska, Tennessee, and Texas continuing legal education credit. Wisconsin continuing legal education is still pending. A recording of the webcast will be available tomorrow for watching and sharing. Once available, a link to the recording will be emailed to you along with a certificate of attendance. And this concludes our webinar. Thank you all very much.